First, we will see 31st Constitutional Amendment Bill and Delimitation Bill, which were introduced, which were defeated, even in Lok Sabha itself. So, nevertheless, the topic is important because it is linked with Women Reservation Act 2023. Now, if God willing, if you are qualified for them, definitely there will be a question in the mains regarding free and fair election, one person, one vote, one value, etc. Delimitation, redrawal of constituencies. These are all the hot topics. So you should know the background. From preliminary point of view, you should know primarily the articles number. Now tell me, first thing, what do you understand about the bill? Why the bill is controversial? What was the allegation against the bill? Today, Prime Minister is speaking at 8:30. Definitely, he will justify the bills. And opposition has already spoken against it. And you may have formed an opinion about the merit and demerits of the bill. Now tell me, what is the gray areas in the 131st Constitutional Amendment Bill and Delimitation Bill and Union Territory Law Bill? Three bills are there. Remember, it is a combination of three bills. One is 131 Constitutional Amendment Bill, which increases the size of Lok Sabha. Second is Delimitation Bill, Constitution of Delimitation Commission, and delinking that is after 2029 census from the Women's Bill, and UT, application of the same provision to UT of Puducherry, J&K, and Delhi. These are all three bills combined. You tell me, what is precisely? I want to know whether you have understood the basic points. What is the because nobody, of course, with due regards, not that I know everything or you know everything, not that. Most of the people, we are all like a sheep. We don't understand the issue, but we always follow somebody. We do not have any individuality. If Narayanan says it should be correct, or you will follow. But we should not be like that. We should decide our own. We should find out what exactly is the problem. Now tell me, in these three bills, what are the gray areas? Why this bill is opposed to by certain people, not certain. Remember, out of 278, 230 MPs, 230 means 23 crore people have opposed to the bill. What is the gray area? Tell me one by one. Let me also learn. Not that I know you don't. You know more than me. Tell me, what exactly is the gray areas? Ashwath? It is only a love. You can be bold. You need not worry about it. You just tell.
First, regarding It's a women's reservation bill, sir. Sir, it empowers the woman, sir. First, the advantages are it empowers the women and it gives a representation in both state assembly and parliament.
No, Mr. Ashwath, you are not understood my question.
Okay.
You are giving the merits and demerits of 106th Constitutional Amendment Act. That is gone. That has already become an act. It is no longer a bill. 106th Constitutional Amendment Act already provides 1/3 reservation in Lok Sabha as well as state assemblies. It is a decided fact. It is not in question. In question is to start the women reservation bill on the basis of 2011 census and constitution of delimitation commission. This is the issue. Here, these two bills are only on that ground. You tell me the reason. So, Bharat, you tell.
Sir, the issue starts from 1971 census, sir. So 42nd amendment, we froze the like delimitation till 2001. Then again 84th, we again froze it till 26.
2000. It was frozen till 2000.
2000, sir. So we wanted to like change to 2011 in 23, but due to COVID, like we couldn't do it.
2011.
So no, sir, we wanted to implement 2011 census. But we couldn't do it, sir. So what center wanted us, sir? This 2026, let us implement the delimitation and then give reservation for women's.
No, what was Constitutional Amendment 1, Constitution 42nd, you said. Then it was ending at 2000. Then
84th, sir.
84th, it extended for
2026.
To 26. Up to 26. Yes. Okay, then
right now, sir. So center wanted to increase its seats to 850 and then give reservation. This Nari Shakti Vandan, sir.
Okay.
Whereas southern states are saying instead of increasing and giving reservation, give reservation in this 843 seats. Or else their interest will be hurt. Because they have given much population control.
Okay.
And under Article 368, if there is any ratification by state, if they give reservation, if they give delimitation based on this 850 seats, North Indian states will have more power, sir.
Where is the question? One second. We should make a statement with the due justification. North Indian states have more weightage. Where? How? How are you saying this?
Ratification of states, if, for example, this delimitation bill itself.
Okay, ratification more than 50 states, 50% of the states, naturally, the ruling party at the center and will always, that I agree. Then where is the weightage for northern states in the bill?
If there is any constitutional amendment bill or anything like ordinary bill isn't passed in Lok Sabha, half of the seats is reserved.
That is true.
North Indian.
How? Please make me understand what exactly the issue. You are saying 2026. 2026, this women reservation bill has already come.
Yes.
So 27 census should be taken. That is any census that's taken after 2029. So 27 census we have 2027 onwards the census. So you cannot hold the election. I mean, women reservation cannot be implemented from 29 election. It is not possible. So what exactly the government wants to increase the seat? They wanted the base as 2011 census. What is the objection in that? What is the objection? Be clear. I just want to know. See, it's not unless you understand the crux concept. You will not be able to answer. Main, you cannot answer. Anusha.
Sir, the problem that people face, professed is that they were linking the women's reservation bill indirectly to the delimitation bill. So it would portray that, okay, without politics. So they had a problem with that because delimitation would be done based on 2011.
Don't generalize. I want specific answer. How that delimitation bill or constitutional amendment bill, women reservation bill, is against the concept of federalism or whatever allegation.
It is not, sir, again, that the same thing that if they couldn't do it without increasing the number of seats, like you said, so they were proposing to do it based on the 2011 census,
Okay.
which the southern states were against because of the population, like Bharat said.
No, that they have already given 50% increase.
But in the total,
Bharat, kindly understand.
Yes, sir.
2011 census is one scenario. One scenario, government says, don't take 2011 census, you take 50% uniform increase. Uttar Pradesh 80, now it will become 120.
120.
120. And this, what is that called? Tamil Nadu 39, now become 59. All states 50% increase. Where is the discrepancy? Where is the contradiction here? Where is the imbalance?
Sir, this 50% is not. If you see in totality, if you club all these North Indian states seats, it will be always more.
No, you are not understood. Even now, the same position is there. Because of the increase in 50% there, it is not going to change the map. Kindly understand. Tamil Nadu today for 39, tomorrow it is 59. UP today 80, tomorrow it is 120. Madhya Pradesh today 49, next time 69. So there is no, all people are given 50% increase. Where is the discrepancy? Where is the ground for your grievance?
Political delays can happen, sir. More number of seats.
No, political
delays.
What is political delay? I cannot understand. What do you mean by political delay?
If more number of seats are there in the parliament, already lots of chaos is happening. Already lots of chaos is happening. If more seats are increased,
does that mean that the women should not be given reservation?
They are linking with the women bill, sir.
No, see, if you are not giving, you know what is the total strength of House of Commons? Do you know? What is the total strength of House of Commons? House of Commons, it is only 50% of our population. Not even 50%. UK population is much less. It is UP plus Madhya Pradesh. Whereas they have 675 seats. House of Commons has 675 seats. Tell me, how can you say that the more number of seats will create chaos? That means how do you give the representation? Bhumika, you tell.
Sir, repeat the question, sir.
Did you not hear? What is the argument?
No. Yes, sir. From which I need to continue?
No, you continue now. What is the controversy in delimitation bill or constitutional amendment bill?
Sir, there may be possibility of gerrymandering.
Huh?
Sir, gerrymandering, if I'm right.
Okay. So where is the question that what is rigging or whatever you say, that retrial of constituency will come only after the delimitation commission is established?
Yes, sir. There is a possibility.
Does it mean that you will not make any reservation?
No, sir.
Gerrymandering. Yes, Bharat.
Sir,
don't think this is a waste of time.
Yes.
I am just throwing the thought.
Sir, firstly, my opinion. Southern states are not against the women reservation, sir. They are ready to give a reservation, women reservation in this 543 seats only.
Within this 543, they want to give reservation for women.
Yes, sir.
That is your opinion.
My opinion.
Okay, Ashwin. Ashwin, you are left.
Sir, no, sir, I'm here in the call once.
Tell me then.
Sir, since there is two scenario like 2011 census and which was opposed by the southern states, but they are now okay with this. And the second scenario is the 50% increase in
No, sir,
for every state.
if the southern states are agreeable, why they have not supported the bill? Delimitation bill.
Sir, there is a proviso in the recent the yesterday's bill where they can. Sir, I'm
Did you
not
go
able.
through the bill, delimitation bill? Anusha, did you go through? Bharat, did you go through the delimitation bill?
Yes.
Huh?
I didn't go to the proper bill, but full summary I've read it, sir. I've read an article. I have read multiple articles on this, sir. Before class also I have read properly.
கொஞ்சம் உட்காரு நீ உனக்கு ஒன்றும் தெரியல. See,
Sir,
tell you, I understand, but you have only, with the due regards, you have only grasped. You have not gone into the deep. It is very difficult. First thing you should remember is, Bharat, your point is, remember, very important, one person, one vote, one value. This is the heart of Article 81 and 82. One person, one vote, one value. Kindly listen to me carefully. All the Lok Sabha seats, 543 seats, should be allocated to states as far as possible on the basis of population. This is number one. Number two, within the state, the constituencies are allotted as per the population, uniformity, as far as possible. What is the principle behind this? One person, one vote, one value. With the arguments you have put, Bharat and Anusha, you have put, I feel you have not understood the meaning of one value. Please remember, in Kerala, one constituency has uniformly 7 lakh voters. One MP represents 7 lakh. In Tamil Nadu, one MP represents on an average 15 lakh voters. In UP, one MP represents nearly 23 lakh voters. Now, kindly understand, one person, one vote. Yes, everybody has got one vote. It is not violated. But the MP of the Kerala, a person in Kerala, the value of his vote is more than the value of the vote of Tamil Nadu. A person who is living in Tamil Nadu, a person living in Kerala, if we see the value of the vote of Keralite and value of the vote of Tamilian, the value of the vote of Keralite is more than the value of the vote of what is known as the Tamil Nadu. So remember, so basically, this is that you cannot ignore value. That is not the solution. Value is equally important to one person, one vote, one value. That is called uniformity. That is all the exercise. Allocation of seats within the state, allocations of seat every state is based on these three principles. Remember, number one. So you have to have uniformity. As far as possible, if you read the article 81 and 82, as far as possible, there should be equitable distribution of population. That is, one cannot represent 18, 20, 23 lakhs, and another cannot represent only 7 lakhs. This is disproportionate. Now, another thing you should remember is, number one, I have told you. Number two, these are all basics. Free and fair election is the basic structure. Remember, free and fair election is the basic structure. Which case declared this as a basic structure? This was declared as basic structure in Raj Narayanan versus Indira Gandhi. In fact, Indira Gandhi versus Raj Narayan case. Raj Narayan case, Raj Narayan versus what is known as Indira Gandhi. In this case, Supreme Court, when it examining 329A of amended article, Supreme Court declared that it is nullified and said free and fair election is the basic structure, rule of law is the basic structure, judicial review is the basic structure. You should remember. These three are basic structure. So, number one. So, what are the articles governed in this? Article 81, Article 82, and also Article 170 and Article 80. All these things are there. We will come one by one. So, remember, this is number one. What I told you is the basis of the point which we said. Now, another thing you should remember is, Bharat has already told, it was originally constitutional, what is the actual word here used? As and when the allocation should be done on the basis of the population among the states. That is, seats in Lok Sabha should be allotted to the states according to the population. Within the states, constituency should be allotted according to the population. Both are according to the population. Only population is the criteria, even though many other criteria can be attributed. As far as possible, Delimitation Commission, so far the 4 Delimitation Commission maintained only population as the basis. First point. Secondly, 71, it has been frozen. Which article, which amendment? 42nd, as you correctly said. 42nd Constitutional Amendment Act, 1976. They said, no, it is not possible. They froze because of the instead. They have not cited any reason for it. If you see the statement of objection reasons for 42nd Amendment Act, they have not revealed it. Because you cannot say you have controlled the population, Northern state did not control population. You cannot say in black and white. So this was not revealed in the statement of objection reasons given in the Amendment Act. But the implication is because Southern states faithfully implemented family planning and Northern states did not implement it properly, so there was a population imbalance. So to stop that, Mrs. Gandhi froze this up to 71 census. Till when? Till 2000. Okay. Then Atal Bihari Vajpayee came. He came in 2001. In that 2001, he extended this up to 2000. That is 2000, then 2026. 2001 is the amendment, 2026. It was amended. Simultaneously, 2021, it was 26. Up to 26, it's valid. 2023, the Women Reservation Bill came. Women Reservation Bill, 1/3 for Lok Sabha, 1/3, that is a separate, totally different issue. Now, the bills, now 3 bills are there. 3 bills are there. One is constitutional amendment, that is size of Lok Sabha. Second is delimitation. Third is UT. UT is immaterial because whatever provisions we say, it is equally applicable to Puducherry, JNK and Delhi. That is not a big issue. The two main constitutional amendment act is, one is 103, what is known as 131st, that is size of Lok Sabha. Size of Lok Sabha, there was a, another thing is, Constitution, you should read the Constitution Article 81 very carefully. What Article 81 says is, every census should be held every 10 years, decadal census. Immediately after census, the delimitation, it's a mandate. Remember, Article 82 gives the mandate. Constitution gives the mandate to the central government that you conduct census every 10 years, and immediately when the census are published, you constitute delimitation commission. So, and why you are asking, why the Constitution says you constitute the delimitation commission? Because the census done after every 10 years will be the basis for delimitation. That was the intention. So, these two are mandatory. What two are mandatory? One is census every 10 years. Second is constitution of delimitation commission immediately after 10 years on the basis of the census published in the decadal census. So, remember, 2011 means 2011 census. 2021 means 2021 census. 2031 means 2031 census. It was not possible. Now, what the government has done is, see the first point, that is size of Lok Sabha. I am first talking about the size of Lok Sabha. Government has done is, delimitation commission is to be constituted. What they have played here is, they kindly listen to me carefully. What they have done is, Constitution mandates that the delimitation commission should be set up immediately after the decadal census. This is mandate. Who will constitute? Parliament can entrust this to any authority, not necessarily election commission. Ranjana Desai was there, and the election commissioner Kuldeep Singh was there. So it is not necessary that the election commission should do it. It can be entrusted to anybody. Point you should remember is, this is constitutional mandate. Decadal census, immediately when the census figures are out, you should constitute delimitation. You cannot bifurcate, you cannot escape from constituting the delimitation commission. Now, they have amended 82. What they said is very important, innocuous. Outwardly, you will not know. Inwardly, what they did is, they removed this mandate. They said, the Constitution empowers this to the Parliament. So, Parliament can establish a commission, that is delimitation commission, not necessarily after every census. It can be established after 2 census, 3 census, and which census is to be taken, that also the law will decide. Remember, very important. Constitution says every census you have to constitute. Every census you have to constitute. What the law says, what the Constitution is being amended now, the Parliament will make a law when what is known as census will be held, and when the delimitation commission will be constituted, and which will be the basis for delimitation commission. In other words, the constitutional mandate has been taken away. Now there is no need to amend the Constitution. Once this is approved, automatically the powers come to the Parliament. Parliament will make a law. This delimitation commission is constituted now. 2011 is the census figures is the base. Accordingly, remember, now 2011 census is taken. Next, after 5 years, not necessarily census figures. They can say, no, the next census we will take. So the entire prerogative has been given to the Parliament. Why you are afraid of Parliament, you can ask. Because why you are afraid of Parliament? Parliament has got the ruling party is there. You are also having a role in the. Why you are afraid of Parliament? We are not afraid of Parliament. But remember, you give the powers to the Parliament. Parliament will make amendment by simple majority. Constitution can be amended by special majority. Now, if you entrust this to the Parliament, Parliament will make law by simple majority. There is no need for a special majority. You remember again, you refer Central Information Commission. The Act said Chief Central Information Commissioner tenure was 5 years, according to the original Act. Remember? Now what they have done, and he was made equivalent to Judge of Supreme Court. What they have done, they amended the Act. They said as prescribed by the government. Now what is the tenure here now? 3 years. What was the rank initially given to him? Cabinet Secretary. So once you entrust this to the Parliament, similarly take Election Commission. In spite of Supreme Court having said the Chief Justice should be in the selection group, what you have done? You have taken away that. You said Prime Minister, and then a minister nominated by the Prime Minister will be in the selection committee. So once you entrust this to the Parliament, normally the ruling party, whichever party, today BJP, tomorrow it may be Congress, day after tomorrow some other party. I'm not talking about the party here. The party in power will get the powers to modify it to their taste. So you are now amending the Constitution to give the powers to the powers as it is available. This is the major drawback here. So remember, this is the bone of contention. Another thing. Now what they have done? 2011 census. They said they have given this. Many people have been led or misled by the scenario 1. Scenario 1 is what is known as scenario 1 means lump sum ad hoc basis 50%. You are very happy. I am very happy. Tamil Nadu 39, Tamil Nadu will get 59, Karnataka of 38, now they will get 58, 50%, 50%. Everybody is happy. There is no discrimination. UP also gets 50%. I am also getting. No. Remember, till what time? Till the Delimitation Commission submits its report. What is the Delimitation Commission census basis? 2011 census. Now 1/3/2027, it will be out. The Delimitation Commission will take 2 years. In 2029, what will be the basis? 2011 census. If you apply 2011 census, Tamil Nadu will be getting 7 seats less. Kerala will be getting around 2 seats less. UP will get about 15 seats more. Madhya Pradesh will get more than 15 seats addition. This imbalance, they are not rectified. This cannot be rectified because once you approve, once you get through this, give this constitutional mandate, if you delink this from the Article 82, automatically all powers will go to the state, will go to the Parliament. So Parliament will make. Remember, that is I will read the salient points, you will be able to understand. Of course, I will send you this also. Delimitation would be in proportion to the population. That is, they have kept it. Now, as per Article 82, the delimitation will have to be carried out after every census, underline. And such a delimitation will be based on that census. This is a constitutional mandate. The present constitutional amendment bill empowers the Parliament. Remember, empowers the Parliament to determine when the delimitation will be undertaken and which census will be used for such delimitation. Very, very important point. The separate delimitation bill introduced simultaneously provides that the latest published census as in the date of Constitution of Delimitation Commission will be used. What does it indicate? This means the 2011 census will be used for next delimitation. As per the Constitution, the maximum membership of Lok Sabha 550, 530, etc. Now 106th CA 2023 provides reservation. The present, remember, provides a reservation of 1/3 total seats in Lok Sabha and state for women. This will come into effect based on the first census after the commencement of 23 Act. The present constitution amendment bill removes this requirement. No, you take it. It is not after the act coming into force. It is now itself. That is how they want to give the reservation from now. The Delimitation Bill 2026 gives the powers to the central government to establish a delimitation commission to carry out the delimitation. Then another point here is, what is delimitation has not been defined, which is given in the constitution, they are not defined. The commission will comprise of one person equal to Supreme Court Judge, Chief Election Commissioner and State Election Commissioner, that 3 people associates. Then in addition, what are the defects? Kindly listen to me carefully. Article 81 and 82 provide that the delimitation of seats in Lok Sabha will be undertaken after every census and will be based on the latest census. But the bill provides that Parliament will, by law, decide when to carry out the delimitation and which census is to be used. Parliament can make this with a simple majority. Since the government will always have a simple majority in Lok Sabha and Rajya Sabha having weaker position, the government will have an upper hand to decide when the delimitation is to be held and which census is to be the basis. In simple words, there is no constitutional certainty on the periodicity of the delimitation and the use of what is the census to be used. That has not been here. As per the existing provisions of the Constitution, the allocation of seats to the states in Lok Sabha should be based on 71 census until the first census after 2026. The present proposed bill removes this position and allows for the next delimitation to be based on 2011 census. The change may lead to a significant shift in the share of the states in the total seats in Lok Sabha. If you calculate the basis of 2011 census, the seats for Kerala will come down from 20 to 15, Tamil Nadu will come down from 39 to 32, and Uttar Pradesh will see an increase from 80 to 89, and other northern states also. Remember, 2011 census will give an undue advantage. To escape from the criticism of the southern states, the government has come out in an ad hoc increase of 50% uniformly. But remember, this is only an ad hoc arrangement till the delimitation commission orders are implemented. Remember, another important discrepancy is Rajya Sabha. Okay, you have given Article 81, Article 82, Article 170. Okay, what about 80? See, now what will happen? 850 Lok Sabha seats. Rajya Sabha 245, 233 plus 12. Is there any value for Rajya Sabha in the president election? In the vice president election? What is the value of the vote of Rajya Sabha MP? What is the value of vote of Lok Sabha MP? Who will win? What is the use of Rajya Sabha having it? Tell me, joint session. Joint session, already it is difficult for Rajya Sabha to function. Now Rajya Sabha you are not touching at all. Rajya Sabha you are not increasing. You are increasing only, and you know you have not touched that. You have increased the legislative assemblies. They will increase. But what about Rajya Sabha? Rajya Sabha already it is a fifth wheel in the coach. Nobody respects it. All bills you say it is a money bill, money bill, money bill. Already it is pending in the Supreme Court. Now what will happen to that? Number one. Another, you see a halfback. I do not know. I don't say I am expert, etc. Halfback, they never give. There is no imagination. Okay, you did not touch any other provisions. Under Article 75 of the Constitution, Council of Ministers' strength should be 15% as the what is known as Lok Sabha. If you see 15% of the Lok Sabha, what should be the Council of Ministers' strength? 122. 122 ministers. See, already you ask any MP informally, they don't get time to speak. No, there are 0 already, even 2 minutes, the speaker will say, sit down, sit down. You might have seen in the live telecast. Nobody has time. Whether it is 0 hour discussion, whether half an hour discussion, short duration discussion, calling attention motion, it's all in ballot. then you are not getting time, adequate time, 543 MPs in the Lok Sabha. Now 850 MPs, how will you get? And what is the role of Rajya Sabha? How you are going to strengthen the Rajya Sabha? It's not there. Secondly, what is delimitation? It has not been defined. It has not been defined. So another important thing is it did not define, and with the increased number of members, the opportunity for each MP is completely to raise the questions and the issues is very limited. So these are all the gray areas as far as amendment bill is concerned. Remember, it is very important. You have to remember the articles. The Rajya Sabha, this has not been touched. The amendment bill increases the seats in Lok Sabha from 550 to 850. Rajya Sabha strength left untouched. It means that under the Article 83, the present Rajya Sabha strength will continue to be only 245, maximum 250 members. The relative share of Lok Sabha will increase manifold, and the disproportionate increase of Lok Sabha will have a cascading effect. In other words, this will reduce the relative share of Rajya Sabha in the election of president, vice president. This will also increase the powers of Lok Sabha in the event of joint session. You can well imagine the strength of Rajya Sabha being 245 and Lok Sabha being 850. What are Rajya Sabha they can command respect? Why do you keep Rajya Sabha? Why don't you say 2 seats for all the states, only 2 states like the Senate? No. You want what is known as outsiders also, nomination also, and you want imbalance also. UP will have so many members and Sikkim will have only 1 member. What sort of federalism? So that is another point. We should have this. So if you have any doubt, I will send you the notes. The point of irritation is they have removed the constitutional mandate from Article 82, delimitation. Because under the Constitution, every census, the moment the census figures are published, it is the duty of the Parliament to constitute delimitation commission. That provision has been removed. Now it is Parliament. They can constitute delimitation commission anytime they want. They can say this census will be the basis for delimitation. So it is totally left. Another point, you should not see only one point. Now you are under the impression that why to keep it? Even many of the political leaders are saying why we should keep it. We will freeze the number for another 20. There should be an end. See, the stabilization of population has not happened till 2011. The census reveals. Now it is 2021, it happens or not. You should find, otherwise the basis of democracy is 1 vote, 1 person, 1 value. Remember, that is very important. An MP representing 7 lakh in Kerala, an MP representing 23 lakh in Karnataka, or 28 lakhs in UP is totally imbalanced. This does not stand to reason. For a country which has 130 crore people, we have 543 members, means it is not correct. You have to increase. How to increase? That is the point, you have to ponder out. You cannot say 50%. These are all ad hoc. That should some rationale. What is the rationale? Normally it is population. If you give the other factors, terrain, or like finance commission category, special, then again special categories, it's all Parkinson law. Everybody who is close to the power, they will manipulate. So you have to find out the solution to enhance the number of seats. At the same time, it should be equitable distribution among the states. That is very important. That is the requirement. You cannot say completely, no, we will keep 543. And that is anything which is static is scale. Nothing can remain static. Even constitution, that is why we do not have the judges for life, because their mindset is always old. Why? After 6 years, what 6 years after that, what Ramana did is different. What is this person's Kannada does it different. So every judge differ in his opinion. Nagaratnama is more progressive. Previously, if you see all, you might have seen so A.K. Gowal versus Union of Manaka Gandhi versus Union of the Golakanath versus Union of India and Kesavananda, all because of the age. We do not keep the judges for life. We are changing. 6 years you go out. So that should be the attitude. We should have a what is known as delimitation. Every censor that should be implemented. You have to find out without any dispassionate. I mean, without any. I mean. Interest, vested interest, you should decide. That is the normal thing, it should take it up. Okay. Now, if there is any doubt, you can ask me. In this. Yes, Bharat.
No, sir. No doubt, sir. Not in this, sir.
What is it?
Not in this topic. Sir, you told constitution should be evolving every time. So, what I wanted to speak is about women reservation in Supreme Court. Some other topics, sir, but not related to this. They themselves say like district courts have more women representation because it is based on merit. Whereas in the Supreme Court, like Justice Nagaratma herself told that let them sit in the bar council and come. So what is your opinion on this, sir? She herself being like, she's going to be only for 36 days. As
She
Chief
will
Justice
be the first Chief Justice.
Yes.
She will be the first Chief Justice.
When Supreme Court is criticizing other places, women should have representation. Supreme Court itself is not having. So my question is, somewhere constitution should be silent in few topics because appointment of judges itself, constitution is silent. So even this in this delimitation.
So you tell me point blank, you want that the ladies should be given preference in the district
Given,
court?
sir.
Women
Ladies already they have sir decent representation because district court it is based on merit.
That is the point. You should be, see, remember, I personally feel the reservation for women is itself a disgrace for women. I personally feel. Left to me, I say the woman should not seek any preference. Where even in the working place, even in it is a disgrace. It is like physically challenged person asking for seat. So according to my stand, all women are equal. All men and women are equal. Why do you want reservation? You should come up. Maximum the reservation may be till the college or post graduation. You give all facilities to them. You pay all the fees to them till education. But then the competition, etc., they should compete. They should come on merit, whether it is judiciary, whether it is legislature. That is not there. Once you give reservation, that means you are backward. You are back. I feel it is a sense of shame for any person to seek for reservation. The reservation means it is like that. LPG quota. See, normally what is, even if you are brilliant, you go to, see, that is the mindset. So to overcome this mindset, I will say that any woman, she should compete on the basis of merit. Suppose Narayana. If I write in a biodata, I tell you, according to me, I am not duffer. Slightly equal to intelligent, if not intelligent, at least to some extent intelligent. I can handle any issue with due regards. If I give a biodata to some MNC, some association, if I say Narayanan Iyer, one biodata, Narayanan Paswan, another biodata, they will choose Narayanan Iyer. The same person, I can give a challenge to you. I can give a challenge. This mindset should be changed. This mindset should be changed. We are only led by the cost. The same thing happens with a woman. You are saying you give reservation. Why you are seeking reservation? You fight. You fight. Is it not a disgrace for other 360 people telling them you take this thing? Is it not a shame? Tell me. You should organize women power in such a way they come to the road. They come to, you see the France. You see the France. How they got the voting power? They got the powers of vote because of the fight. How many people will come except the CPA, CPM? I have never seen ladies coming out of the street and fighting for the rights. Only labor people will fight. Other people no. That is my personal view. I do not say my view is, nobody will accept my view. That is my personal. Tell me, brother.
Yes, sir, you are correct.
So my humble view is, the lady should say, I don't want anybody. I will come up. You give me education. You give me education. That is important. There is no level playing field in the education. Any family you take, they will educate the son, they will not educate the daughter. They will send the son to the MBBS, engineering, MBA, Roorkee, Bidani, etc. They will not send the daughter. They will get her married. This should be a penal offense. I will say to the extent of, they should be penalized. They put them in the jail. If Bentinck is again born, he will do the same thing. That should be till they get the master, till they are free. They should provide them maximum education. All professional colleges. But once they qualify, they should be equal. There should not be any discrimination. There should not. They can. If they are going on tour, they have to accompany. If they no, I am lady, I cannot go. My husband will be waiting. My daughter is suffering from fever. I am not. All these things, humbug should be stopped. You should give them full education. You should be bold enough. That temperament is there, which I personally feel, but 99.9% of the people will not agree to it. It is too radical to think. So this is apart from this, tell me.
Clear.
So, okay. Now, another point. Places of Worship Act. See, we are taking this. What are the current topics, current affairs, which are possible for exam? Let us say instead of places of worship, now in continuation of this, national emergency. National emergency, you know, Article 352, Part 18, 352, 353, 354. 352, proclamation. 353, effect. 354, distribution of revenue. These are all the three, Part 18. This is important. Why it is important? 50 years of 25th June 1975. Emergency is declared on 25th June 1975. When it was withdrawn? 21st March 1977. How many months it was there? 21 months. Why you talk? There were already 3 emergencies. Why do you take this emergency? Why not you celebrate the first emergency, second emergency, third emergency? Why are you pitching upon this emergency? You are politically motivated. All this. No. For the first time, this is the first emergency which was declared in the peacetime. Remember, you should. Other 2 emergencies, 1962 and 1971, both were declared due to external aggression. This was declared as a result of internal disturbances. So, this is the first national emergency which was declared on the peacetime. Remember, this is very, very important point. Secondly, another important is, we should know what are all the amendments from exam point of view. I'm talking about exam point of view. What were the constitutional amendments which are brought during the period of emergency? Because normally, especially during this emergency, during Chinese aggression or 71, there was no constitutional emergency, the constitutional amendments. Whereas the peacetime emergency, these 21 months have seen a number of constitutional amendments. So that is important from exam point of view. What are those constitutional amendments? First amendment, 38th Constitutional Amendment Act 1975. It has barred, that is embargo, barred the courts from questioning the presidential decision to declare emergency. Remember, it was subjected to judicial review till then. Even now it is. What Mrs. Gandhi, 38th Constitutional Amendment Act 1975, she said Supreme Court cannot question the decision of the President to declare emergency. This is 38th Constitutional Amendment Act 1975. Number 2, 39th Constitutional Amendment Act 1975. What she did, she excluded, underline, she excluded the election of Prime Minister and election of Speaker from judicial scrutiny. Second. Third, 42nd Constitutional Amendment Act. 42nd Constitutional Amendment Act, which is otherwise called a mini constitution, she has made, number 1, all the directive principles were placed over and above the fundamental rights. Number 1. No judicial review on constitutional amendment. If it is a constitutional amendment, no judicial review. Second, Supreme Court, High Court powers have been curtailed. Number 3, it was added that no constitutional amendment can be questioned by any court on any ground. Remember, no constitutional amendment can be questioned by any court on any ground. Another beautifully worded. What is that? Central law can be questioned only in the Supreme Court. State law can be questioned only in the state high court. Remember, not only that, for striking down a law, the judges, normally what is the strength of the constitutional bench? 5 judges. What she said is, if you want to examine a law, the minimum judges should be 7 judges for Supreme Court, 5 judges for High Court. Number 1. Secondly, another most importantly, if you want to invalidate a law, the majority out of 7 judges, 2/3 judges should support. Remember, these are all not novel or story. You can check up 42nd. This will not be, this may be new to you because all these things have been nullified by the higher Supreme Court. That's a different issue. So it requires special majority bench, that is 7 for Supreme Court, 5 for High Court. To declare a law invalid, at least 2/3 of the judges of the bench should agree. Simple majority is not enough. Today, simple majority, it is not enough. Lok Sabha and state assemblies term permanently increased from 5 years to 6 years, just for 1 year, because her seat has been declared void. She has been disqualified for, say, 6 years. She said all the Lok Sabha and state assemblies, the term will be extended to 6 years. Remember, this is on record. Under Article 226, High Court can issue writs for any other, you might have read. What are the powers of High Court under Article 226? They can issue the writ for any other purpose. They can issue the writ direction, any other purpose. That any other purpose has been deleted. No. High Court can issue writ only where there is a substantial negation of principles of natural justice. You cannot issue for any other purpose. That was also done. It was removed and modified as there was a substantial failure of justice. All the above judgments, remember, all the above judgments have been made null and void by the Supreme Court in Minerva Mill case 1980. Number 1. 43rd Constitutional Amendment Act 1970 is very important. 43rd Constitutional Amendment Act 1977 restored the powers of the Supreme Court and High Court. That is, status quo ante was restored. Then Janata Party came to power. And remember, most importantly, it may be sarcastic. You cannot say, as of today's circumstances, they may ask this question. 25th June is, observed as Samvidhan Hatya Divas. Very important. They may not ask, but if the paper setter is anti-Congress, anti-Indira Gandhi, definitely this question is sure. 25th June is observed as Samvidhan Hatya Divas. Very important. And this was to ensure that this day is not forgotten. That is the purpose. Secondly, Shah Commission established by the Janata Party. On the recommendation of the Shah Commission, 44th Constitutional Amendment Act was made. It brought many amendments. Number 1, internal disturbance was replaced by armed rebellion. You might have seen. Judicial review restored for all future proclamations. Number 3, written advice of the cabinet. approval within 1 month instead of 2 months. Written at the secondly, special majority in both the houses. Earlier it was simple majority. Now it is special majority. Emergency to be revoked if Lok Sabha passes a resolution by simple majority. For imposing, it is special majority. For revocation, it is simple majority. And in addition, to convene Lok Sabha session, 1/10 of the member should give a notice. Article 19 stands automatically suspended during external emergency only under Article 358. Remember, Article 19, 358. All fundamental rights, Article 359. You should remember the 358 external emergency, 359 all. And even 359, Article 20 and 21 cannot be suspended. JDM, Jabalpur. Remember, very important case, JDM Jabalpur case, where the HR Khanna has given an adverse judgment. Later on, he was overlooked also because of this fault, because he stood by the freedom. Article 21, he was debarred. He was not considered for, that is the Sanjeev Khanna's, the Chief Justice, earlier Chief Justice, his father, HR Khanna. He was overlooked. Secondly, another Article 19 revived, another most important. Suppose you make a file, there is a violation of fundamental right. You go to the Supreme Court, and this is during emergency. Supreme Court said, no, emergency is there. I will not entertain any petition against, even if there is a violation. Okay. But after the expiry of emergency, you can file. Another important thing. Even though during emergency, you cannot file a writ petition before the Supreme Court High Court for violation of fundamental right during a period of emergency. You can file a writ petition against such retrospective violations after the emergency is over. Very important decision given. Secondly, Article 20 and 21 never suspended. Judicial review powers of the Supreme Court High Court restored. The term of Lok Sabha for 5 years and Assembly for 5 years restored. During emergency, the term was made 6 years, as I already told you. Secondly, another thing is, any question of violation cannot be raised in Supreme Court, that I told you. What is the case of Mrs. Garg? You should know. There is what is the case actually happened? Say she was elected from Rai Bareli, 1971 election, where she came with thumping majority, and her election was challenged by what is known as Rajanarayan, and the case was decided by the Allahabad High Court. She she used the government machinery, and the government, R.K. Dhawan, who was this in the role of Consolidated Fund of India, he was the election agent. So her election was nullified and she was disqualified for 6 years. Remember, she was disqualified for 6 years. She made an appeal. V.R. Krishna was the Chief Justice, he was the judge of Supreme Court. He said she can continue as the Prime Minister. Why? Because even if you are not a member of Parliament, you can continue for 6 months. So you can continue as the Prime Minister, but you cannot vote. So he allowed. During that period, she brought all these things. Remember, that is very important. She appealed to the Supreme Court. Supreme Court granted conditional stay. She can remain as Prime Minister but cannot vote. To overcome this handicap, remember, she brought 39th Constitutional Amendment Act 1975 and added 329A. What does it? Exempting election of Prime Minister and Speaker from judicial review, number one. Secondly, 329A4, it was given retrospective effect to 329A. Because why retrospective? By the time already Allahabad High Court has ordered, so she gave retrospective. What we have done in Office of Profit, the same applied. It was given retrospective. Her election was made valid as a result of this. On November 7th, 1975, Supreme Court quashed 329A, saying it is violation of basic structure. Supreme Court also said judicial review, rule of law, free and fair election are basic structures. It has also declared the Parliament cannot use constitutional amendment to protect any individual, much less the Prime Minister, from the electoral malpractice. This was the decision of the Supreme Court. So these are all the points where you will get the preliminary question. It is possible. All these things are very important from exam point of view. Secondly, now let us come to MCQs. What Maria, you call it? 276.
All option C, sir. All the above.
All the above. Bharat, eh?
Yes.
Bharat, all the above.
Sir, option C, all the above.
All the above. Yes, Ashwin. Kindly read the statement carefully.
Sir, B2 only, sir.
B2 only. Ashwat. Ashwat or Ashwin?
Sir, let's see all the above, sir.
All the above. Anusha.
Sir, A1 only.
A1 only. Yes. Tell me quick. Bhumika. Darshini.
Sir, all the above. All the
All the
above, sir.
All the above. Darshini.
Sir, option C, all the above.
All the above.
Sir, all
What
the
is
above,
this?
sir.
Okay. See, one only is the correct answer. You have not read the second statement carefully. RBI is mandated to maintain economic growth with the price stability in mind. And in this regard, RBI Act 1934 was amended in 2016. See, you know the inflation targeting framework, which was signed by Mr. Modi government and the RBI. Inflation targeting framework for 5 years. What was the purpose of this? See, there are two goals. One is economic growth and another is price stability. We were giving importance only to the economic growth, neglecting the price stability. That is why the inflation was running uncontrolled. When Modi took over, the government said you should give emphasis to the inflation targeting, price stability, not economic growth. So keeping economic growth in mind, mandate is to maintain price stability. So price stability gives importance and economic growth secondary importance. It is other way about. Bharat, you should read the statement very carefully. So remember, the objective of RBI was changed in 2016. Now the priority is inflation targeting and price stability, simultaneously economic growth. So the two aims are there, of which we give importance to the price stability rather than economic growth. Second, 277.
All the above, sir.
All the above. How many statements are correct?
All the Above.
All these
All three.
Sir, B2 only. I mean, 2 statements.
only 2 statements. Okay.
Sir, B.
B. Ashwin B. 2 statements.
Yes, B, sir. Bombay.
Sir, B2 statements only, sir.
2
Sir,
statements.
option B2 and 2 statements.
Darshini?
Sir, option B, sir.
B. Anusha, what is which statements are correct? Which
Second.
statement is wrong?
The first one is wrong, sir. It's a convention, not an account. It's not given in the RBI Act.
Very good. That's correct. So there is no mention about the accounting here in the RBI Act. It is only an internal decision of the RBI. So remember, first 2 are correct. So this statement is wrong. Okay, next, 278.
D, sir. Option D.
Option D. Option D. Ashwin says D. Yes, Bharat?
Sir, option B.
Option B.
Sir, D,
Option-
sir. Delhi, sir.
Yes.
D, Delhi, sir. Delhi.
Delhi, very good.
Bombay B, sir.
Bombay B. Bhumika D. Tell me. Darshini? Darshini, tell me. Anusha, which statements are
B.
wrong? Yes, Darshini, correct. Tell me.
Sir, option B, sir.
Huh?
Option B, sir.
B.
B2
Very
statement.
good. Okay. Anusha, Darshini, tell me why these 2 statements, which statements are correct? Tell me quick. First statement, tell me. RBI was set up as a private shareholding bank in 1935.
Correct.
Yes, sir. Correct, sir.
Huh?
Correct,
Yes,
sir.
Bharat? Okay, correct. Okay, then it was RBI was set up as a non-statutory body on the recommendation of Hilton Inc. Commission.
Wrong, sir.
Which is
Wrong,
statutory
sir.
body, sir.
It is wrong because it was a statutory commission. It was under RBI Act 1934. So naturally it is statutory, but they have private share. And 1 share was costing how much rupees? 1 share of RBI at that time, what was the cost? Yes, Darshini. 1 share of RBI at that time, what was the cost of share? Anusha,
No, sir.
when you read this, you should have known this. Bharat, you tell.
Even I don't know, sir.
See, it was set up as a statutory committee. It was statutory because it was constituted under RTB Act 1934. It was private holding and the share was 100 rupees. Remember, the share was 100 rupees. And the original paid up capital is only 5 crore. Even now, it continues to hold only 5 crore. MRS may differ, but even now it is 5 crore. Okay. So RBI was set up statutory body only on 1st April 1935 under the provisions of RBI Act 1934, private shareholding, one share costing 100 rupees, RBI accounting year, now is April to March. Okay, then 279.
Kopya.
279. Tell me. Pick
Option B, sir. Two statements.
option
B, Bombay.
Bombay. Yes, Darshini. Quick. Ashwin.
Sir,
B.
Bombay B.
Bombay B. Omega B.
Sir, B, sir. Bombay, sir.
Bombay. Bharat.
Sir, B, sir.
B. Very good. Correct. B is the correct answer. With reference to RBI. RBI was set up as a 279. Sorry. The central government can issue directions to RBI in public interest. Correct. It can give direction under section. Which section? Which section? Which section of RBI 1934? You should remember there are certain sections. Demonetization. Central Board of Directors. These are all very important sections. Section 7. Section 7 of RBI Act. Very important. You should not forget. So they can issue that and they can supersede also. That is under Section 7. Transfer of dividend from RBI to central government is what is the mutually determined every year. Is it correct?
Wrong, sir.
Huh?
It is wrong.
Wrong.
Incorrect.
Anusha?
It's wrong, sir.
Why?
It is not mutually decided. After the surplus is met by RBI, the rest of it is transferred to the government.
No, is it mandatory? They will not keep anything.
They keep a buffer, sir.
Buffer. What is the meaning of buffer? So don't generalize the statement. Don't generalize. These are like a 12th standard student telling. They get the surplus, okay. So in a range and all these things, whatever amount they get, and there is a charges. Yes.
They'll keep the contingency risk buffer.
No. Remember, there is a committee. Bimal Jalan committee. Bimal Jalan has recommended a capital committee. It's a capital account committee. And the committee name is Economic Capital Framework Committee. Economic Capital Framework Committee headed by Bimal Jalan. That committee has recommended a formula. And following this formula, the surplus amount is transferred. It is not mutually agreed. It is not ad hoc also. It is not as if after deducting, it is not a broker. You have to follow the guidelines issued by Bimal Jalan committee. Very, very important point you should keep in mind. Next,
Sir,
280. Yes.
sir, the committee itself. Okay, nothing, sir.
Tell me. Yes, 280.
So only option 2.
Option 280. உள்ள வந்திருக்கு ஆப்ஷன் கொடுக்கல.
Sir, only one statement is correct, sir.
Only one statement is correct.
One statement is correct, sir.
Understand. One statement, two statement, three statement, none. Sorry, it is incomplete.
Two statements are correct.
Two statements are correct.
Sir, Bombay B, two statement.
Two statements. See the statements under section 21A of RBI Act. All state governments signed an agreement with RBI for RBI to act as their banker. Is it correct? Is it statement is correct?
No, sir. Sikkim is an exception.
Huh?
Sikkim is an exception.
Sikkim is an exception. Bharat, tell me you. Is it correct? Whether Sikkim is an exception?
Yes, sir. I thought it is correct. Now, even I'll say now it is incorrect. Sikkim is an exception.
Ashwin?
Sir, I thought first statement is right.
First statement is right.
Yes.
No. Anusha is correct. Sikkim is an exception. Article 371F. Article 371F empowers Sikkim State Bank of Sikkim to act as their bank. Remember, so the first statement, the agreement has been signed by RBI with all other states. Either the RBI or the SBI or any other bank authorized by the RBI will act as their banker. But for Sikkim, it is an exception. Okay, then unified market interface is a digital product designed to tokenize financial assets of single window interface. And UMI was launched by Market Division of Ministry of Corporate. Why second statement is wrong or first statement is wrong? What is it? Tell me. What about the second statement? Is the second statement correct?
Yes.
Huh?
Yes, sir.
Correct. Second statement is correct. One statement is correct. Then third. Third is correct. UMI
No,
was
sir.
UMI was launched by Market Division of Ministry of Corporate Affairs
RBI
in late
launched it.
2020. Huh?
RBI launched it. It was launched by RBI, sir.
RBI. Bharat, you tell me whether it is correct.
Statement is wrong. Anusha is correct, sir.
RBI Act 1934 in October 2025. Okay, next. Next, 281. Tell me 281.
Sir, option B.
Option B.
Yes. B for Bombay.
Tell me, Bharat. B for Bombay.
Sir, option B, sir. 3 only.
Option
B, 3,
B.
Bombay 3 only, sir.
3-1. Anusha, what was your
Sir,
answer?
Bombay B.
Bombay B.
B,
Bhumika.
sir. I said B.
Bharat.
I said B, sir. 3
Bharat.
Sir, even I'll say B, sir. 3 only.
Very good. B is the correct answer. I agree. B is the correct answer. Project M Bridge is also called, what is the other name for this? MCBDC. It is an international collaboration to solve pain points of cross-border payments like speed, cost, and transparency by using CBDC. So this is the correct. With reference to the concept of synthetic CBDC. Next.
All the above, sir.
All the above.
Sir, option B.
Option
B.
B. 2 and 3.
B, Bombay. Yeah.
Sir, option C. All the above.
All the above. See, first statement, it is a form of CBDC issued by RBI based on the distributed ledger technology. No, it is not issued by RBI. It is not directly issued. It is issued by the private investors. RBI is backing it. So remember, that is number one. It is a form of CBDC for cross-border payments. No, it is not for cross-border payments. It is a form of CBDC which is used for selective purposes. This was earlier. Now it is extended to all. So neither is the answer. Remember, it was earlier selected select institutions. Now it is extended to all. Next. (284), 283. Yes. Very important. Carefully tell me.
Option D, sir.
Huh?
D.
D. D or B?
D for Delhi, sir.
D for Delhi. Darshini?
Sir, option C, all the above.
Yes.
Sir, option C, all the above, sir.
Very good. Tell me. Next. Bhumika.
Sir, option C, all the above.
Bharat?
All the above.
Very good. All the above is the correct answer. All the above. Because somebody said neither. It is wrong. You know, UMI is very important, of course. This is a proposed digital platform developed by RBI for trading and settlement of tokenized financial market instrument using wholesale CBDC, not retail, wholesale. Secondly, settlement through wholesale CBDC is UMI enabled delivery and payment, and therefore it addresses the delay in settlement. UMI is intended to benefit the retail investors to invest in financial instruments like bond, G-security, corporate bonds, etc. So all the above are correct statement. So we will end here. We will continue. We have got another 40 MCQ. We will see tomorrow. Tomorrow class is there, same timing, same time. Tomorrow we will take Places of Worship Act and another important Ladakh Schedule 6. They wanted Ladakh, and you know Sonam Wanchuk, social activist, and Ladakh has demanded statehood and to be included in Schedule 6. So it is a current affairs. So Schedule 5 and Schedule 6, what is the difference between the two? And what is the, you should remember there are states which are special status. Super special is Article 370, which has been made inoperative. Then there are special status, category status, 371, 371, etc. Special status, special category status, that is 12 states. So this is here, Schedule 5, Schedule 6, Schedule 5 is 10 states, Schedule 6 is 4 states. So you should know the difference between all the 4. What is special status? What is special category status? What is 371? The special status, constitutional special status, all the you will get a definitely, because these are all gray area. Nobody will read it. So definitely you will get, and if you mark it, you will gain. Otherwise, if you ignore, it is a loss. Everybody will ignore it. Most of the people, because nobody will give attention to these dry topics, difficult topics. Nobody will be able to understand. So these topics which are difficult for others to understand, we will see. Number 1, we will see rest of the, and another important topic is Schedule Places of Worship Act. Then 356, again Manipur. So that is another hot topic, 356. Okay, thank you. Good night.
Thank you.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you.